Tushara, you can start.
I'm waiting.
Thank you.
Waiting to start.
Tushara. Thank you. Thank you. Am I audible? Am I audible?
Yes, yes, yes.
Yes. Respected senior members of the bar and dear colleagues. I think on an evening after a long day of work, waiting for the next one for tomorrow, the timing may be a little too hard on any one of the listeners if I make a very serious discussion on any legal topic for that matter. However, I thought this topic, unlike the other topics which may have too much of legal jargons attached to it, may invoke some curiosity in its listeners for the simple reason that most of us, if not all of us, particularly being mostly women here, may have been subjected to privacy violations in our public lives. I grew up in the suburbs of Kottayam district, and some of my happiest memories of childhood are about my time spent with my cousins in a largely joint family setup when we could be together during weekends or holidays or as and when possible in the ancestral house where we had limited number of bed spaces for a large 25 plus family. I think we shared everything: food, clothes, even bed spaces. And we were too happy about it. In the world in which I grew up, privacy was a casualty. I hardly knew about it. And I'm sure some of you may also agree with me. If we recall our days when we did not know who all interfered in our matters, just about everybody had an opinion to make with regard to our personal decisions, be our choice of career, our interests, our marriage, even at what spaces we should have our children. Now, I'm a mother of two teenagers, strong and smart, with their own spaces. I see them quite anxious when they do not have the number of followers or likes as they would have expected to be in the social media world in which they are so grossly engaged in. They have a larger world than mine. They have a larger network than mine. They are probably truly international than I am. In a world far different from which I grew up in, but I see that for them also, privacy is a casualty. Over the decades, probably over the centuries, one of the most discussed, debated topics was that concerning privacy. Even recently, if you see, there have been quite a number of cases, critiques, which have come up with regard to the manner in which the very concept and essence of privacy has been defined and probably discussed as well. My attempt is only to share with you some of my thoughts with regard to the subject, not particularly in a fashion that would mean about a rollout of the judgments, but just to share with you a few ideas of what I consider is an evolving concept, is a dynamic concept in the world in which we are now living. Privacy, I think, is a word which lacks definition, which is very hard to define. If we try to define privacy, I think we must also go back to the roots of the word, the history of the word. Privacy, actually, the concept of privacy, in fact, arises from Aristotle's theory or division of public and private life. the division between oikos, O-I-K-O-S, and polis, P-O-L-I-S. In Aristotle's definition of life or the spheres of activity, he divided this between public, the oikos, and private, the polis, or the domestic sphere of a man's engagement. This philosophical concept of privacy was later discussed in the essay by John Stuart Mill on liberty. In this essay, which I'm sure most of us have at least heard about, if not read, while we did our graduate courses in law, talks about the divide between the governmental authority and the private spaces where probably we can have self-regulation or containment in our private spheres. However, this historical concept of privacy, if we trace its origin, finds a clear voice in an essay authored in 1890 by Samuel D. Warren and Louis D. Brandeis. The essay is titled "The Right to Privacy." It was published in Harvard Law Review, and this essay still controls the definition of privacy in all judgments, if you can see. According to Warren and Brandeis, privacy is defined like this. I'm just quoting the relevant portion so that we move on from this conceptual definition of what privacy is to a more dynamic understanding of privacy is in the modern age. According to Warren and Brandeis, the intensity and complexity of life attendant upon advancing civilization have rendered necessary some retreat from the world and man under the refining influence of culture. Solitude and privacy have become more essential to the individual, but modern enterprise and invention have, through invasions upon his privacy, subjected him to mental pain and distress, far greater than that could be inflicted by mere bodily injury, unquote. Now, this definition of privacy actually could not go any far beyond this, because at that particular time in history, there was actually no definition or the scope for definition of the privacy through judicial pronouncements or publicized through judicial pronouncements. If you see, when you move ahead from the 1800s to the 1900s, you see a shift in the attitude of how privacy has been defined through jurisdictions. In fact, in Europe, there was an essay, as you know, that at that point in time, unlike probably the times now, there were always academicians that ruled the field, discussions by academicians, professors who gave their opinions, their views, philosophers who actually defined the concepts, and those concepts were then imbibed into judgments. In Europe, the concept of privacy, as was in the US, never really found its fit. The problem between the two jurisdictions was that while one tried to concentrate more on individual privacy, the other, that is the European jurisdictions, tried to focus more on informational privacy. It is for this reason that William Prosser in 1960 attempted to define privacy as part of tort law, that is the law of torts. According to Prosser, in fact, it's interesting to note that this definition comes a long way after the first definition to right to privacy, which has come in the 1890 by Warren and Brandeis. According to William Prosser, there are 4 specific types of privacy which will have to be looked into. One intrusion upon a person's seclusion or solitude. 2, public disclosure of embarrassing private facts about an individual. 3, publicity, placing one in a false light in the public eye. And 4, appropriation of one's likeness for the advantage of another. Now, these varying concepts of privacy later evolved to a discussion on the types of privacy. Now, as we move on to the types of privacy, as I referred to earlier, we have 2 separate branches of privacy which are generally considered. One is pertaining to informational privacy, which related mostly about publicizing certain elements by way of print media, because that was the major source of communication and publicity at that point in time. So giving away information about oneself, which is damaging or false to the public against the private assertion or interest. However, this informational privacy slowly turned down to individual privacy, probably with large-scale intrusion of media, probably with more understanding, more travel, more globalization, or probably because of the fact that there was a change in the perspective of morality as was at that point in time. So informational privacy and individual privacy as separate branches of privacy ruled the field. Apart from this, the theories of privacy gave 2 other aspects of privacy, because if you just see, if you try to make an analysis or a search on what exactly are the types of privacy, you see 2 definitions to it coming under 2 heads. One is descriptive privacy, the other is normative privacy. Now, descriptive privacy is basically a plain understanding, a plain explanation of what, according to general societal norms, privacy is considered to be, probably the value, the standard, the ideal that is set in. Whereas normative privacy is something what is ought to be, what you intend to achieve. It is more personal in nature. Now, as we discuss about this topic in 2022, I'm sure we all understand that the world we saw in 2017 with the Puttaswamy judgment is no more the world that we see in 2022. Probably in the landmark judgment of Puttaswamy, landmark in the sense that it established privacy as a constitutional right, the important thing that was considered was how to handle and how to contain personal information, personal interests, and personal prejudices without being exposed to public eye. However, as we move across, I'm sure the change has been quite fast. As we move across and stay back and look at it in 2022, the most important aspect of privacy that we are now to deal with is privacy concerning with us in the digital world, which is digital privacy. So from the traditional concept of informational privacy, individual privacy, normative and descriptive privacy, we come down to a very different aspect, which is digital privacy. Now, when we look at it that way, next point that probably we can talk about is what exactly is privacy? If this is so, can we define privacy? Because there are variations to privacy, there are different concepts, there are different branches. How do we define privacy? Now, individual privacy has always been said to be the United States, the champion of individual rights. In fact, started with the case of Griswold versus Connecticut, a 1965 decision, which overturned the convictions of the director of Planned Parenthood and a doctor at a Yale Medical School. I do not know how many of you are aware of the decision. The basic issue therein was that the director of Planned Parenthood and a doctor was in fact vocal about use of contraceptives between married couples in married life. This particular aspect and the fact that instructions on information pertaining to contraceptives were given to married persons was considered to be infringing upon the private realm or private matters of marital lives between couples. The definition went on to say that you have no business, the state has no business, nobody has any role in what married people do or choose to do in their private lives. So the 1965 decision of Griswold versus Connecticut started a series of judgments thereafter, which pinched upon the concept of privacy as essentially touching upon the principle of morality. Thereafter came the decision of 1973 in Roe versus Wade. As you know, a very famous decision, all of us have learned about it over and over again, where the issue concerned was pertaining to the health of women, the right to abort, as to the choice of a woman, whether or not she should keep the pregnancy or not. Now, in all these situations, the test was the balance that has to be done between a governmental authority and the private individual. While analyzing cases of this nature, the courts consistently relied upon the definition that was given by Warren and Brandeis, which is the right to be let alone. If you see the latest judgment, the Puttaswamy judgment, which in fact, I do not even have to go into it because most of us have been hearing about it. Even when you look at that judgment, the judgment also relies upon this basic definition. What is privacy? The simple answer that you can have is privacy is a right to be let alone. It is simply, in the modern generation's language, if you put it, saying, get lost, this is my life. So the right to be let alone, or the right to control your life without interference from the public at large, is the core essence of what we can understand as right to privacy. When we move on from Roe versus Wade, we come to the decision, a 1986 decision of Bowers versus Hardwick. Now, in this case, the Supreme Court, the United States Supreme Court, upheld a Georgia state law that was banning sodomy. Thereafter, in Lawrence versus Texas, which is again a 2003 decision. Now, here the question was criminalization of homosexual activity between consenting adults. The Texan law that criminalized the homosexual acts was struck down, and the right to privacy of individuals was upheld. There are two other recent judgments, which is again United States versus Texas, which dealt with the Texan law, which deals with the question of abortion once the fetal heartbeat has been detected. And then the case of Whole Women's Health versus Jackson, which is a 2021 decision. Actually, it is an ongoing issue because the matter has been taken up in appeal pertaining to the rights of abortion providers vis-a-vis the right to abort. Now, in these 5 or 6 judgments which I have referred to, primarily from the United States, you will see a pattern. The pattern relates to clubbing privacy with morality. Now, the question is, where does morality fit in to the question of privacy or the concept of privacy? Privacy, as has been defined, is a right to be let alone. If it is a right to be let alone, how was it that courts, professors, academicians, philosophers have always tried to club morality with the basic concept of privacy. In my humble view, every specific aspects of one's individual life, our existence, our relationships, our private spheres, our interests, our sexual orientations, our choices are all essentially defined by certain moral standards, which are always flexible. Let us, for example, look at ourselves. How were we defining our lives during our childhood, during our teenage? I see senior advocates here. Sumati ma'am and Simantani ma'am probably would think, in fact, I fondly recall one specific advice which was meted out to me when I was sharing a concern pertaining to my own children and how different it is raising them from the way I was a child myself to my parents. Over a period of time, standards of morality have been reset, redefined, in tune with the standards of morality that have been ever-changing. Standards of privacy also ought to have been changed. However, the basic standard of privacy is always connected to the question of morality, and it is suffocating within itself in the realm of number of judgments because the courts views it from the standard of morality which existed at an earlier point in time. With the evolving change of moral standards, has the courts across changed its norms, its views, its parameters on what privacy ought to be. If you see the US courts, while emphasizing the individual right to privacy in issues pertaining to abortion, in issues pertaining to sexual orientation, in matters of sexual choices, there are even cases where the state interfered when married couples in the privacy of their homes was viewing video clips, which according to the state, which was not in accordance with the then prevailing moral standards. When it was brought to public, then the state proposed to penalize and punish the so-called offenders. So moral standards have been one specific area which crept in while interpreting the standard of privacy as far as individual privacy is concerned. When we move on to informational privacy, I do not know how many of you have heard about 6 degrees. Have you? 6 degrees is the first ever social networking application, at least the one that I could understand from the text, to whatever the latest that you can have, Instagram and Snapchat or the latest, most of which I learn more from my son than from any other source. So the exploitation and use of personal data, the manipulation, the use, and probably the application of personal data is what led to discussions of informational privacy. Now, when you look at informational privacy, some of the most important case laws have come from the European Union. Have you heard about the Planet 49 GmbH decision, which came very recently, which in fact redefined how even the cookie policy will have to be used? If you see, when you are accessing social networking platforms or downloading sites, very frequently you see the terms and conditions of use, you see the cookie policy, and what we do is click on the button, and because we are in such a hurry that we need the application to be downloaded or we want to access a site, we just click it in and we say that, all right, let's go ahead to the next page. But now it says, I'm sure you also have seen the cookie policy, which basically tracks your user information, your browser history. Now the new cookie policy in the European Union, pursuant to this decision, that is the Planet GmbH decision, says that it is not enough if you simply have a one-liner saying that this cookie policy I am accepted, but you should specifically say this cookie is being used for such and such a purpose. And unless you go to that, click on every particular tab, every particular option, then the understanding is not a complete understanding. And if it is on the basis of that the particular, the site host or the application provider is floating the cookie policy, they can be taken to task, you can sue them. So informational privacy, over a period of time, there have been a number of decisions also pertaining to this, which has been strongly dealt with by the European courts, finally culminating in the latest decision of Planet GmbH, gives a lot of responsibility to media houses, to social networking platforms, to tell you how your personal data will be exploited or used, and also gives you the right to block them from using your data for specific purposes. In the European countries, in particular, of course, it has been developed in US also, very intermittently in the Indian courts. Privacy has been often defined as an issue in tort. And it is for this reason that privacy invasions are referred to as tortious claims. We have a number of judgments also on that count from Europe, which, as I said in the beginning, I did not want to give you a list of judgments or, have a citation rollout on it, because that's not what we are probably looking at this time. We have decisions as early as from the Queen's Bench to the latest decision in 2005, where the right to interference in private affairs by public authority and governmental authorities have been deprecated by various European courts. We have the famous decision in Campbell versus MGN Limited, where a celebrity model got a writ issued against the Daily Mirror newspaper because they published an article against her with a headline, "Naomi, I am a drug addict." Now, this was in 2001, after coming into force of the Human Rights Act. So as far as the judgments are concerned, the judgments have very frequently referred to the Human Rights Act as far as the local legislation, along with the judgments, while interpreting how privacy rights will have to be considered vis-a-vis the public standards set out for that. Now, moving from the concept of informational privacy, let's come to the Indian situation, which will also take into account the issues of digital privacy. Now, what are the international covenants that have been regularly referred to by Indian courts as well, while we refer to the privacy law? First, we have the Universal Declaration of Human Rights, 1948, in Article 12, which says that no one shall be subjected to arbitrary interference with his privacy, home, family, or correspondence, nor to attacks upon his honor or reputation. Similarly worded is Article 17 of the International Covenant on Civil and Political Rights, 1966. Then we have the European Convention on Human Rights, the 1953 document in Article 8. In fact, it is this Article 8 of the European Convention on Human Rights, which has been frequently referred to in European courts now, so that they can track down the cookie policies. It has been also referred to in the Planet GmbH, the latest judgment, which I just referred. Article 8 says, everyone has the right to respect for his private and family life, his home, and his correspondence. These international covenants, along with the national legislations, supplement the moral standards and definitions which have been set in through various academic reports and essays. Now, as far as the Indian scenario is concerned, as you are all aware, we have discussions on privacy starting right from the A.K. Gopalan's case. In A.K. Gopalan's case, where search and seizure was considered, and whether there was infringement of right to privacy in considering search and seizure, the question of privacy was turned down. We had again privacy issues coming up in Kharak Singh versus State of UP, in MP Sharma versus Satish Chandra Bose, in Govind versus State of Madhya Pradesh, in R. Rajagopal versus State of Tamil Nadu, and a number of decisions spanning decades which addressed privacy as the right to be let alone. Now let's put it this way. What exactly to you and me will be privacy? My home, my personal belongings, my reputation, my family, my correspondence, which would include all types of communication. And now we go a little further to say, a space which I have built up in a virtual world. Here we come to the question of digital privacy. You know, I fondly remember how we used to have a lot of playtime when we were children during our younger days, even now for that matter. It's very difficult for most of us to understand how exactly you can be excited seeing the number of followers or likes or the virtual realism that you may have in a space which you don't see, in an area where you don't go, with things that you don't touch, and with emotions which you actually send in the form of smileys. So a lot has been changed, and therefore, in a world in which we are actually dealing with things which are more unreal than real, probably more complex and maybe a little difficult to communicate as well, the question of digital privacy is one of extreme relevance. Now, this leads us to a better understanding of our own law as far as right to privacy is concerned. Now, while the courts in India consistently refrained from holding privacy as an inalienable right in the constitutional spectrum, the 2017 judgment of Puttaswamy versus Union of India boldly comes forward while deciding the issue of the validity of using the biometrics for the purpose of Aadhaar card, coming down to say that right to privacy is not just a legal right, not just part of a tortious right, not just part of a right which you can claim vis-a-vis social standards and moral ethics. It is not just a dynamic concept depending upon the facts and circumstances of a case, but it is a constitutional right and is an interplay between the right to equality, right of the freedoms guaranteed under Article 19, and the right to life and personal liberty, which is guaranteed under Article 21. Why the judgment is called a landmark judgment, or why the judgment is probably often discussed as the one that laid down the concept of right to privacy into a more meaningful spectrum, is only for the reason, I would say is only for the reason, because if you read the judgments authored by, separate judges, most of it goes ahead. There is always a repetition as far as the idea is concerned, but the fundamental idea is to hold it as an inalienable, uncompromising right, which guarantees to every individual the right to life and personal liberty, dignity, and existence as a fundamental right, elevating him to the basic right which evolves around everything, which is right to privacy. So right to privacy is breathed in to Article 21 and shows it as an interplay between 14 and 19. Thus, what probably the constitution makers omitted, failed, or refused to do by guaranteeing it under the fundamental rights in Part 3, the court has boldly gone ahead to say that no, there is a right to privacy, and that is part of your inalienable fundamental freedoms under Article 21. Now, this relation with Articles 14, 19, and 21 is called gamut of fundamental rights. That is what the judgment actually refers to. Now, I do not want to go into the details of the judgment as such, because a number of judgments also have been referred in the particular judgment. You may also be interested in going through the decision in CLE and others versus State of Karnataka, which actually dealt with the question of narco-analysis, the polygraph examination, the brain electrical activation profile, the beep, whether there is a privacy issue involved in such situations, etc. Now, K.S. Puttaswamy versus Union of India, which actually refers to this right in the concept of privacy as an individual fundamental right, is relevant for specifically two reasons. One, it cuts across the traditional concepts of morality by breaking the notion that morality is a rigid, standardized format. Two, the judgment introduces into it or breathes into it an air of fundamental right which otherwise would not have been available for us while we pose a challenge to privacy issues. Now, this judgment is very relevant in the context of digital privacy. Now, I'm sure that as parents, most of us have always been quite vocal in telling our children, don't do this, don't upload this, don't send this picture, don't download this data. And why do we say that? The only reason we do that is because we are worried whether the right to privacy of our children are being compromised. Not the right, but the privacy is being compromised. We are worried whether the information will be misused, whether the cookie information will be taken and exploited, whether the information that is taken by networking sites will be transmitted to sites, security agencies may be exploiting it. We do not know at what point in time this can be taken by third parties to use it against us. So we say that this is a warning signal to you not to give out your personal information. If that be so, what is it that we really need? What we really need is probably a stringent and stricter law as far as digital privacy is concerned. Now, we have the Information Technology Act, which is in fact the basic law that relates to internet privacy in India. And we have a number of decisions also. I'm sure you may have gone through the decisions of the NSA leaks case, the case, the Pegasus case, the WhatsApp case, all where we have been seeing how privacy was compromised through domestic servers. Now, the problem that we often find as far as the internet is concerned, it is very difficult for us to have the jurisdictional impact because you may have domestic servers hosted in one country. So the information that is transmitted from here to a domestic server which is located in another country, which typically happened in the NSA leaks case also, where information was given out, servers were located in US. So in a country with less stringent privacy laws, the information could be used or misused with no fear of the citizen or the person bringing in a legal claim for invasion of privacy. So what probably is going to be the biggest challenge, because if you see that now we have rules pertaining to how cyber cafes will have to be used, how surveillance mechanisms will have to be introduced, how sensitive personal information can be transmitted online, all these rules have come. We have the personal data protection bill, which is in the pipeline. So a number of regulations are now in the offing. But the question is how far we will be able to enforce it. The practical aspects of its implementation is also to be looked into while we try to balance the concept of digital privacy vis-a-vis the concept which is imbibed as a fundamental right in Article 21 through the Puttaswamy decision. So Puttaswamy decision with the 2017, the declaration that privacy is going to be a constitutional right, is it possible for us, or is it enough for us to stay there and say that, yes, I have a fundamental right to privacy now, which I can enforce against the state and which I can also against vis-a-vis anybody who is violating my right. But to what extent is it practically possible for us to use it, to actually implement it in the context of digital privacy, which is the most challenging privacy concern that we have as of date? Now, yet another angle of privacy, which I thought may be relevant to just point out as a food for thought for you, would be, is it possible for us to waive a fundamental right? Is it possible for us also, because it is one thought that came to my mind when I was actually working for a case, is it possible for us to have a reasonable expectation of privacy? Is it possible for any person to say that vis-a-vis you, vis-a-vis a statute, vis-a-vis a regulatory authority, I say that I do not want to have this particular right? Is it the definition that we give to waiver? Of course, as you know, fundamental rights cannot be waived, as has been given by a number of legal decisions you have on that. But in the context of digital privacy, when we click on application buttons to allow us access to particular sites, are we compromising or waiving our fundamental right to privacy? A question, I think, which has never been answered because it has not really come up as an issue before the courts. But the aspect of digital privacy being compromised by an explicit or implicit waiver by the party is one area which is going to be a challenging one. So also is the reasonable expectation of privacy. Now, I say that when I move about, when I travel, when I speak, when I access online courts, when I even do e-filing, I have a reasonable expectation that what I do will be protected. Protected not in sense of the security, but protected from public outlash. That what I do in the private confines of my home, what I talk, what I share, and what I probably choose to do or not to do will not be the subject matter of public debate and discussions on social networking sites, media platforms, or any public platform for that matter. Now, do I really have this reasonable expectation? Is it maintainable? And if I am permitted to have this reasonable expectation, is it possible for me to file a case challenging violation of my reasonable expectation of privacy and asking the state to enforce my fundamental right to privacy because it exists under the circumstances, because otherwise my reasonable expectation to privacy was there? Is it possible? Now, this again is, I think, an area which needs a lot more discussion, because in spaces, in platforms, I'm sure you know that we are dealing with in a world where economic transactions have become in cryptocurrencies, where NFTs or non-fungible tokens are in frequent use, where money is made more by thinking about money than by acting for money, where most of our activities, even before we complete the activity, is a matter of public discussion, where almost everything and anything you do or not do is subject matter of somebody else's business. How far is it possible for us to maintain this reasonable expectation of privacy? And how effectively can you assert it, even if Puttaswamy declares privacy as a constitutional right? Now, as regards waiver and reasonable expectation of privacy, probably we will have cases in future, and I leave it to your good conscience to think over and maybe decide upon at some point in time. Now, closely related to this, I just wanted to point out one interesting right connected with this. I do not know how many of you have read on it. There is something called right to be forgotten. Most days, we wake up and the first thing that we do is access our WhatsApp. We are so uncomfortable if we just don't take our phone, search the WhatsApp, and it is as though like a ritual. Some people are very comfortable sending good morning messages. Some are very happy just by the fact that we are able to access WhatsApp. So as social media has crept into our daily life so terribly, sometimes we access it fully knowing that nothing of what is written is right, but fully conscious of the power of the social media to manipulate our thoughts, our actions, and sometimes our images. In such a situation, what happens if social media builds a particular image? Say, for example, as lawyers, we argue for our clients. Our client is an accused in a particular matter. He continues to be an accused until the final court of appeal, everything is over. There is a final decision to the matter. He is either convicted or he is acquitted. Let us take, for example, a situation when he is actually acquitted. Don't forget that we are all living for the moment. We are very happy, probably too happy, seeing sometimes the misfortune of others, however temporary that be. So we see on the media platforms an accused being talked about, too much of discussion on what he did, how he did, etc. What happens if after 5 years he is acquitted? Then a person who accesses Google, searches for his identity, will only get information pertaining to the videos pertaining to or the news pertaining to him being charged of an offense. He remains to be an accused in all searches, probably somewhere at the end of 5 years or 10 years. Some media may report about the acquittal. What if it does not? And even if it does, what about the 100 other searches which has gained prominence over the period of time? Because the first thing when you click on that name, you may be getting only information pertaining to the accusations that have been made against him. In such a situation, Delhi High Court and the Madras High Court has come forward to say that there is something called right to be forgotten. So if there has been an acquittal at a later point of time, or if your name has been cleared from the allegation that has been raised against you at a point and later cleared, then the search engines are expected to go and correct the names, the information that have been given about that particular person, the particular organization, or the particular facts and circumstances, so that the person can exercise his right to be forgotten. Have you not seen sometimes when you wake up in the morning and access your in the frenzy to access your WhatsApp, you also see that there is a Google memory which is given to you. The Google says before 7 years you did this, before 5 years you did this. I don't even want to think that I look like this 7 years back. I am not comfortable thinking that I was talking about this 7 years back, but doesn't help you. Google will compulsorily tell you what you should do, what you are supposed to remember, what you liked to eat, where you went. So almost every activity of yours is tracked, traced. Forget that. You are even told about it, even though you don't want to remember it. Think about a person being told about his first husband or first wife after you have moved on with another one. Think about what the Google reminds you of, what you may want to forget. Think of what happens to lives, to relationships, to careers, to any activity that you may have, if you are constantly reminded in the Google, in the social networking platforms about what you have so hard struggled to forget and probably remove from the public database memory. So the right to be forgotten, in my view, is probably the best manifestations of the constitutional right to privacy. Now, there are a number of judgments that have also come ahead in the area of right to be forgotten. For lack of time, I think it may not be fair on my part to embark upon those judgments at this time. There are also a couple of foreign judgments from various jurisdictions. In fact, we have one from the New Zealand also during the COVID time, where there was a specific reference to a star, to a film star who was actually modeling for a particular cosmetic item, and thereafter came in to say that she was not using the item anymore, and she sued the company for having given statements about her earlier where she was using it. So right to be forgotten is a very strong manifestation of the constitutional right to privacy. Now, my attempt was only to share with you a few thoughts on what I thought the idea of privacy is, not really to analyze any particular judgment. In my view, what is very important at this point in time, since I see a number of female advocates, also my friends here, not that I am in any way not noticing the male lawyers, but I would also say that I feel that for the women in particular, the raising of right to privacy as a constitutional right is something to be very happy about. In Virginia Woolf's Room of One's Own, I think what every woman craves for is a space for herself, is an area where she can call her own, a space, physical, emotional, even intellectual. So this carving of private space to be free from interference in every possible way, physical, financial, mental, intellectual, in every possible way, lies at the very core of our existence. And for all, men and women, boys and girls, irrespective of gender, sexual orientations, preferences, choices, careers, pathways, I think the most important thing that we should always have and also respect so that others can also have is the right to privacy. With these few words, I thank the organizers for having called me to share my thoughts on the subject. I'm not an expert, but I did read up a little bit, having given this chance to, and I'm very happy about it. With whatever time left, if it is possible, I shall just try to take a few points on discussion.
Thank you so much, Dr. Tushara James, for precious sessions. Thanks to all winding up the session.
Thank you very much, Tushara. It was a wonderful session. You have given us insight into various aspects of privacy, right to privacy. I was really surprised to note that there is a right to be forgotten. It's a new concept which I have learned from you, and I hope others too. My congratulations. Not only for you, but also for Kerala Federation of Women Lawyers.
Shantakumari, thank you for attending our program.
It is our program.
Yes, our program.
You did not thank me. It is our program. I love to listen to all of you. That is especially Tushara.
Shanta. Yeah, very happy to see you, Shanta.
Ma'am. Hi, ma'am. I was keeping quiet for a